I'll try and do a good job with handwriting. In your experience with custody cases in Quebec, a child over 14 years old is usually listened to in court as far as their preferences are concerned. However, if there is alienation that is proven or suspected, will the judge go against the child's preferences?
My answer would be that it depends on the judge. There have been cases where children were past the age of 14 and the judge did comment on it, but where it's really an open and shut situation where alienation and dramatic cases of alienation, I'm not talking about just a little bit of mild or moderate, I've seen that the judges have gone with basically severe methods to basically stop the alienation. So again, I just want to remind you there was also a case recently in Toronto or in Ontario where it was argued, well, the child is more than 14 years old and the child is expressing his wishes, and the judge, I believe it was a boy, and the judge basically stated, yes, I understand that, the age of 14, and I understand that there's an expression of one's wishes. However, this is not the child's wishes, this is the parent's wishes, and therefore, in that particular case, I believe that the judge ordered that deprogramming for the child, and there was quite, because of the amount of financial expenses that were undertaken in repetitive court proceedings, the target parent was awarded a huge amount of money, several $100,000, because of what they went through, because it was alienation.
All right. Next question. Is there a questionnaire given to children or to parents to see what kind of, if any, PAS is going on? How can we get this questionnaire?
That's a very interesting question. I happen to know that there is a parental alienation questionnaire that's being prepared. It's being prepared not so much in terms of the questions, but also in validating it and giving it to a population of alienated children or children who have been alienated. Mm-hmm. It's being done, I think the population is coming from the States, from Florida. There are a few people that are working on it, and I know that having looked at the questions, they really target all the different themes of alienation. So it's on its way.
Okay. Can you describe concrete, underline concrete, ways that a therapist can minimize the potential for PAS to occur? For example, when you see a family in conflict in therapy, not yet divorced, can we prevent PAS before divorcing occurs? Or if I have to wait, or if I have one parent in individual therapy, what can I do to prevent or deal concretely with PAS?
I don't want to make a blanket statement that it could always be prevented, but I will state that if the parents, if their motivation is to do what is best for the child, and that really is their motivation, and they are exposed to the effects of high conflict on the children, on the child or on the children, and they are explained what effect it has on the child of putting the child in a conflict of loyalty, they need to be told, and it has to be demonstrated what the effects, the studies that have been done on the effects of interparental conflict. The children it has to be emphasized that the children need to disengage from the conflict, that the children's identity comes from both parents, and if the child sees one parent as being all bad or largely bad, that's going to impact considerably on how the child sees him or herself. And again, as I said, if the parent is vindictive and really couldn't care less, but is out to win and to teach the other parent a lesson, I don't think that the counseling will have much effect.
I'm going to make a little comment on this issue and present a different sort of perspective from the point of view of what a clinician is involved in doing at the moment in a case that I'm involved in. The clinician is so convinced that the father was a sexual abuser of a 2.5-year-old 9 years ago, that she has affirmatively supported the mother over the last 7.5 years in doing everything she can to prevent the father from being able to see the child. Very recently, I got involved in the case, and as you might have guessed, we succeeded in escalating things. And the court has now ordered that the father start receiving therapy and access to the child, that the child is to receive therapy and not from this particular clinician who the child has been seeing on and off for the last 5 years. The judge decided that he was going to order that a third person, that I was to get together with this other clinician, a likely event, and that we were to reach an agreement on who was going to be the treating clinician to facilitate the reunification. I sent a copy of the court order to the other clinician electronically, and I basically said that I would like you to take a look at the list of providers on this health insurance program that the father has, and could you kindly choose 4 or 5 names of people who you would find acceptable, send that back to me, and I will do a final vetting and send them to the court. She didn't use the names on the list. She chose 5 names and sent it to the lawyer for the mother, absolutely inconsistent with the court order, but consistent with other behaviours that one might expect. And so now we're in a situation where a month has gone by. I've sent 4 emails, and she ignored me for 3 weeks. I escalated it by indicating that if I didn't hear from her in 48 hours, I was going to file a complaint with the Florida Department of Health in regard to her license. She finally responded to me and said, I don't like anybody on that list, so I'm not going to recommend anybody. So there's now an emergency motion being filed. In fact, it was filed on Thursday to have her removed from ever being able to see the child again. Interestingly, the father had the power to prevent her from seeing the child, but his lawyer had been saying all along, no, don't do anything to escalate, don't do anything to escalate. Well, the clinician is a major barrier to the process that the judge is now determined to initiate. Unfortunately, what's ultimately going to happen is that the very nature of that action by the clinician simply provides more evidence of the chaos of this case. So it's wonderful when clinicians do really good stuff. It's not so wonderful when they don't. Okay. How common are bribes in clinical practice? That is, where a parent offers additional financial reward for a favourable evaluation report. I don't know that there's good studies on that.
Well, my last Porsche, I've never had that experience of being offered a bribe. I will tell you that following very few, maybe, or just a couple, following an evaluation, there was the occasional gift for doing, a superb evaluation by one of the parties, which was not accepted. Bribes, absolutely not. It's a whole question. Let's say it's around Christmas and they offer you a Christmas present or something like that. You stay away from it. You absolutely stay away from it. And you document in your file the date. And I'm not saying in negative because it could have been an innocent gesture, but nevertheless, you document in your file that on such a day and such a day, the person offered you X and that you had renounced it. Because in these cases, as I think it was discussed yesterday and as I said earlier, the amount of complaints, are very high. And of course, not in Canada or the United States, but in some places, there might be some attorneys that might recommend, well, why don't you give them a gift? And then you've taken a complaint.
Yeah. What you do see, though, is not as blatant as a bribe. But what you do see are networks of attorneys who will work with one provider. And the consequence of that can be there's sort of an implicit assumption that I, as the attorney, want preference from you, the provider. And if I keep on getting the results I'm looking for from you, then I'll give you all the business in the world. And if I don't, then your business will dry up. That does happen.
If I could just add to that, I don't remember exactly when, but a few months ago, there was an attorney who was examining me on the stand and was saying, well, how many cases have you done for this particular attorney? And I said, I don't remember exactly how many, and how many did you agree with his client? And I said, well, there were cases that I agreed and there were cases that I clearly disagreed. And then, I don't know what happened, there was a lightning that hit me, and I said, if I remember correctly, I believe that about a half a year ago or 3/4 of a year ago, I think I was in a case with you and the other attorney, and it was the other attorney that mandated me, and I happened to agree with your client. Do you not remember that file? Anyway, the judge smiled, and that was the end of that.
Yes, those judicial smiles are always really worth it.
Very heartwarming, I'll tell you that.
You're going to find this hard to believe, but I don't need you here for the answer to this question.
That's wonderful.
The question
I'm staying.
is, no, you got to stay. The question is, would I ask the audience to please raise their hands? See, I told you I didn't need you. If they are affiliated with, first, a lawyer. Okay. It's okay. Thank you. Okay, one. Okay. Mental health professionals. Well, if they are.
Are you mental health? Are you in the field of mental health?
Yeah, mental health professionals. Okay. I guess that you're a mental health professional. Yeah. Okay. All right. Targeted alienated parent. Okay. Good. I'm not sure what other means. I won't ask the other category because I'm not sure what we do with it once we find it. Do we make them stay or do we grill them? Okay, next. You mentioned that it is important that the children know the truth. How can an alienated parent ensure that the child knows the truth without exposing themselves to allegations of alienating the child from the other parent?
Very, very good question.
Good question.
Yeah, that is a good question. All the questions are actually good. Number one, knowing the truth will also come out through the therapist. It does not have to necessarily come out through the alienating, or the target parent. However, I don't think that it's not, yes, no, yes, no. I don't want them to get into a conflict as to what happened. I find that very, very often the best way I find to bring out the truth is by questioning the child, but not in a directive way. Let me ask you something. you say that I really didn't spend much time with you. And I understand that's what you said, and that may be what you remember, and that may be what you feel. But do you remember the time that we went to the amusement park and we got there first thing in the morning and you wanted to stay even after closing time? You know, bringing up, whether it's through pictures, not telling the kid that you're a liar or it's not true, but presenting information that would rattle the kid. I don't mean that in a bad way.
Yeah.
And again, it does not have to necessarily be through the parent. It could be through the professional, the therapist, and also, very, very simply, the alienating parent showing the child that they're not giving up. You know, if they hear that your mother doesn't care about you, or your mother doesn't care about you, and all of a sudden, you know, there's a Christmas card, there's a card, there's a present, there's a phone call, there's an email, if you're lucky enough to get it through to the kid, but that the kid sees, hey, that's not what I've been told. But again, to get into an argument, yes, no, yes, you got to know when to not to go further than that, because it could possibly entrench the child.
It's also very much a function of the age of the alienated, the child.
Very true.
Who's been alienated, because some of the strategies that you might use
Yes.
with younger children obviously are going to be different. One of the things that I've found that's extremely useful is if the alienated parent has got a really good photographic record of time with doing things with the child, especially if it's a video recorded thing. Like I'm involved in a case in Florida at the moment where the parent has maintained a wonderful record of film of doing things like throwing him up in the air at the pool and all of these sorts of things. And if one simply has the quality of family that results in a lot of photography at an early age, it can be really quite helpful, because the child is not only may have forgotten those things, but may have, the nature of the forgetting may be a real repression based on all of the other evolution of the concepts that are being imposed. And when you bring back some of those events, they often trigger other memories, and so that can lead to discussions about all of the things that we did. And of course, all of the things that we did was linked to all of the wonderful relationships that we experienced together. And
Something to this.
of course.
I think it's important that it's the child who should initiate the discussion,
Correct.
not the parent.
Yeah.
Because if the parent initiates it, it will often come across as alienating
As brainwashing the child too.
Exactly.
And I might add as well that, even using photographs, and I totally agree, videos are wonderful. But when you're dealing with photographs, and I did it recently, and I showed the kid, the child that was alienated, quite a few photographs where seemed to be having a wonderful time with the target parent. And I said, well, let's take a look at this picture. So the kid asks me, what, the fact that I was smiling? So I said, well, that's one thing. Well, what do you expect? It's a picture. You're supposed to smile. They often have answers, but my experience is that if you could use photography and take the initiative from the child, for example, when the child's saying that you didn't spend time with me, and et cetera, well, that might be an opportunity to take it out. Absolutely.
And talking of photography, the actual use of video can be very useful during the course of the entire examination, because some of the things that you can capture on video are stunningly valuable relative to the notes that you can otherwise take from an evidentiary standpoint. If you can cut and splice video and the judge is prepared to watch alienation in action, it can be quite useful.
Or taping.
Yes.
And even,
Yep.
it can't be obvious, but again, sometimes, and it depends on the laws in your particular locality, but sometimes, using a tape recorder where you could, and even for yourself, just to review what took place, the give and the take, but even, little gadgets such as this, which is a flash drive, but at the same time is a tape recorder, which holds 60 hours of tape. So again, you know, having documentation of what took place assists you, not only in terms of the backing what you're saying up as a clinician, but even going back over the notes and taking a look at what was said. Notes are notes, but hearing the affect of the child, hearing the mood of the child can be extremely important.
Another consideration there is when you think about the amount of work that's involved in a really complex alienation case, where you may have, say, 3 or 4 children, the amount of data that you get in order to do the work properly is pretty voluminous. And the amount of time that you need to spend to look at each one of the children as they are going through their own crises in this whole dynamic there's just such a lot of data coming through. And you need to capture as much of that as you can, because otherwise, if you're trying to just take notes, you will simply lose massive amounts of detail that may really be quite important. Yeah, all the way up.
Briefly, thank you so much. You made comments about photography and video, and what might your response be for a targeted parent who hasn't seen their child for 10 years or more? The child is now a young adult. Would you encourage that targeted parent put together, perhaps on a CD or DVD format, photos and videos that were taken many years before and send them to the child when there has not been any contact between that targeted parent and the child for, say, 10 years?
And it's out of the blue after 10 years of no contact?
That's correct.
I guess it depends on the situation, number one. Number two, it depends really on the other individual. It depends on their personalities. It depends on their memories. It depends on a lot of stuff. On the one hand, what is there to lose? You haven't seen the child for 10 years. You've got nothing to lose. But again, I think that it's not just going to be a DVD that's sent. There'll be obviously a letter explaining why you're making this effort after 10 years. Yeah. The question, is, and the adult child may say, well, what took you so long? And they may be very upset that you waited that long. But again, there are explanations that have to be provided.
Yeah, this gentleman here has a question.
Just as a comment, in terms of the technology, when I do the interviewing, I use a webcam on top of my laptop. Little webcam, obviously you get consent. And that webcam puts everything onto your hard drive. You don't need fancy equipment or anything. Yep. And they're running around $50. So it's a very, very simple way of getting a photographic record of the interview, complete with facial mannerisms and anything else that you need.
Absolutely.
See, the issue, which I think I don't want to get into the legalities, but the issue is that with if you're talking about getting consent, who is that going to be from? Is that going to be from both parents? Okay, so you have to consider that the alienating parent may tell the child, "Hey, watch what you say. You're being taped," and some kids go wild with that. But again, you have to consider the ramifications.
In a recent case, I spent 30 minutes taping a child telling me that they were going to refuse to be taped.
And the question is why?
The refusal, I cut it off after 30 minutes, but it was fascinating to get that level of conviction repetitively from there were 2 of them. One was a 12-year-old and the other was a 9-year-old. By the way, the 12-year-old there'd been a claim of sexual abuse, again when the child was very, very little, had been disconnected from the father for about seven and a half years, and she had beautiful curls, beautiful blonde curls that were, really tight curls, and a gorgeous complexion. She was about 5'2", and she weighed 220 pounds, and she was 12. But other than that, she was doing just fine. Okay, next one. Is there a difference between alienating modalities, between the gender, as in the gender of the alienating parent?
Okay, I think I touched upon that. In the 60s and 70s, it was felt that the alienating parents were predominantly females. More recent research that I've come across says that, although there's some research that suggests it's almost equivalent, but I still believe that it is more females, but only slightly, if at all.
The question was modalities, not
I'm sorry, I apologize.
the question was modalities, not
I apologize, okay. I don't know if there's been research done on the modalities. My own experience is that one of the factors that I find often precipitates it is a new partner on the part of the husband, of the ex-husband. That's one that precipitates it. I find as well that there's really no big difference in terms of alienation in cases of relocation that could be done by one or the other. I don't find that there's a big difference. I do find issues of abandonment, and that as being the basis, I find that possibly a little bit more among females as well. In terms of the others, I really don't see that much of a difference.
I think the issue is more to do with the psychopathology of the individual parent who's the initiator of the alienation, and not simply
Modality.
just that they have some emotional difficulties, but that they... I'm involved in a case at the moment in which the mother has done this now through two families. She hid her two boys in her first marriage away from the father, changed their names, attempted to change their social security numbers, changed her name, and succeeded in keeping them away from the parent for the first parent for about 7 years, and now is going through a second husband who she's had 4 children with, and been actively involved in alienating the children from him over a period of about 6.5 years. And interestingly, the court has refused to hear evidence dealing with the first go-around because they say it's not germane to the present matter. At which time I simply want to go hit my head against something really hard.
If I could just add,
Yeah.
you know, we take a look at putting the name, I mentioned the name of the new companion on the emergency sheet. You reminded me, years ago I had a situation where the parents had separated almost immediately after birth. And the child was raised to call the grandfather father. And this went on, and actually the child right now is quite a few years older. And gradually the child realized, I was asked to get involved, the child realized that I was doing observations of the father and the child. And this was on a weekly, bi-weekly basis, more or less it was for about almost a full day. And at a certain point, I asked the child, why do you think that he is spending, so much time with you? He said, because he really likes me. And I said, and why is it that you think that he really likes you? Because I believe that he's my real father. And the amount of pressure on this kid changing, that's what triggered it off. The child did not have the father's family name, had the mother's family name, and this went on and on. And I look back, and I'm just going to say this, that when I take a look at doing this work, yes, it is stressful. Yes, there can be tremendous pressure, whether it's from the the parents, whether it's from the professionals that are involved. But I will tell you, when I look back at that case, it makes it worth its while. It really, right now the kid is spending significant time with, going on vacation with the other parent, etc., and knowing that this is his real father.
There's
So
another
you gotta
comment.
hang in there.
I'm sorry. There's another comment that relates to this. Just because you have a family of 3 or 4 kids doesn't mean all of them are equally alienated. In fact, it doesn't mean that all of them are alienated at all, but they may not be alienated in the sense that they haven't bought in to the tape to be played about the negativism of the targeted parent. But they may decide that they are just going to be silent because politically that seems to make sense in the context of the family. And so you may find that in a reconciliation process, a couple of the kids may move real quickly. And you might have 1 or 2 that are, more captured by the delusion that hasn't yet set them free. The good news is when you've got a family where there are a couple of kids who haven't been exceptionally imbued with that belief system, they tend to be helpful in dragging the other kids out of the problem once intervention around reunification takes place. And there's a next question that sort of, you were talking about the real pleasure in doing some of this work. The next question is amusing. Excluding anyone in the front row or on stage, is there anyone in the room who's had a successful PAS story with a child over the age of 10? Success would be defined by a loving, respectful relationship between the child and the non-custodial parent. There's a couple of hands, yeah? Okay. All right. Well, how about the hands of those who are involved in this unfortunate situation and who haven't seen success at this point? Interesting. Okay.
Interesting.
I don't know whether that has anything to do with legitimate statistics because this is an unusual sampling situation. But, well, everybody who had their hands up, both of you, thanks. How can you deal with, and we'll have to stop in just a second, how do you deal with problems of lawyers and judges who aren't willing to even consider parental alienation as valid and dismiss the notion? How can legal counsel be informed and educated of the significance of how to effectively deal with it? That's only a small question.
You're asking me how to deal with that? And this is being taped?
Let's have a discussion later.
And videoed. Thanks a lot.
And distributed.
I must tell you, there's my own experience. They didn't hear the question.
Oh.
But it uses more electricity, and that costs money.
Okay. How can you deal with the problem of lawyers and judges who aren't willing to even consider parental alienation as valid and dismiss the notion? How can legal counsel be informed and educated of its significance and how to effectively deal with it?
Okay, so the first thing that I would say is that I think that the many judges, and I'm talking about here, for example, in Montreal, many of the judges are very, very much aware of parental alienation, and they take the right steps in terms of dealing with it. I've seen it recently quite a few times. Then they've taken drastic measures. There are some judges that may not know as much, and I think that it's up to, number one, the evaluators, the experts, to basically educate. I also think that it's up to the experts to make sure that the attorneys, both attorneys, I should say, have enough information on alienation, which could also be produced into the court record. Again, it is a question of education. And yes, there are some judges definitely that know a hell of a lot more than some of the other judges. I strongly stated earlier that I feel that judges should be seized But again, it's the judges that basically are really have a great knowledge in terms of issues having to do with family law and alienation. Forcing the issue, you can't do that. You can't, I don't want this judge, I want another judge, unless there's a valid legal reason for the judge to recuse himself or herself. But again, I think that it's up to us as the professionals, the therapists, the experts, in terms of the evaluators, and I think it's for the lawyers, and I think that parents need to ensure that they consult an attorney that is very well versed in having handled parental alienation cases, and not just that they know what it is, but that they've dealt with it actively. I think that if they do that, I think that it could be an educational experience for for whoever's hearing the case. But I also would provide documentation that could be adjacent, could be attached to the court record, and should be submitted. But again, it's a very, very good question and has a very difficult answer.
I'm going to make just a couple of comments on that, and then I think we'll probably need to stop. And the first set of comments deals with yes, there are judges in various jurisdictions in which I've operated that get it. The trouble is there are other judges who say they get it, and clearly they don't get it. You can't make the assumption on the basis of their conviction of getting it. The other consideration is that, in the United States, things operate a little differently than they do here in Canada. When you get a judge in the United States, you get that judge and you're stuck with him or her unless there's a recusal. And I do know enough about the system here to know that sometimes, especially in the early stages of a case, you can bounce from one judge to another and not have a judge seize themselves of the case. And that is a great way of creating chaos in any alienation case. The very notion of a system that allows that to happen, from my point of view, is flawed simply because of that. Because it facilitates judge shopping and gamesmanship. And I've been involved in a couple of cases in Canada where we just run up, tens of thousands of dollars playing games between one judge and another until finally, in this particular case, one judge seized himself of the case, and all of a sudden, some of the games stopped because the perpetrator of the games simply couldn't continue to play the games in front of the one person.
I could also add that one of the things that has really helped is the fact that protective services, children, and the DYP, protective services have increasingly in Quebec become more sensitive. Not that they haven't been in the past, but it is an issue to basically retain a file, retain a disclosure.
Yep.
And I know it's the same thing for the CAS in Ontario as well and elsewhere. Parental alienation is considered a form of child abuse. And that's a wonderful step.
Thank you very much. We'll have to stop at this point.